The remit of my talk will concentrate on corporate criminal liability following deaths at work caused by COVID-19. This will involve an analysis of the legal definition of PPE and the law in relation to corporate manslaughter. I'll also be touching upon some of the governmental guidance that's been provided about PPE so far, and you'll find all that source material in a separate leaflet that Colleen will give further information on at the end of the talk. Unfortunately, due to time restraints, I won't be touching upon the regulations for self-employed, nor on personal liability through gross negligence manslaughter. Both of those topics are worthy of a webinar in themselves. But for now, I'll be focusing upon corporate manslaughter and liability for employers. To begin with then, I'll start by defining PPE. It stands for personal protective equipment, and when spoken about, it might evoke imagery of Hurt Locker EOD suits or Walter White hazmat suits, but it's defined in the regulations as much wider than that, as all equipment is intended to be worn by a person at work, which protects them against one or more risks to their health and safety, including goggles, gloves, basic safety equipment. Currently, the need for PPE is unprecedented. The UK has experienced over 30,000 deaths and rising, and according to the Office of National Statistics, there have been just under 2,500 deaths under the age of 65. According to some reports, there have been 119 identified deaths of NHS workers from COVID-19. And what this means is that there are many people who have likely been exposed to COVID-19 at work, and many people who may have died from that as a result. So the question is, will the employer, as a corporation, be liable if they hadn't done more to protect their employee? The offence of corporate manslaughter is defined in the 2007 Act, and it states that the organisation is guilty of an offence if in the way it manages or organises activities causes a person's death and amounts to a gross breach of a relevant duty of care. So once the employer is considered a qualifying organisation within the Act, one of the first questions to ask is, what duties do they owe the employee? There are general duties to keep your employee safe. However, there are specific duties in relation to PPE, and these are encapsulated in regulations in 1992. Regulation 4 there states that every employer shall ensure that suitable PPE will be provided for their employees who may be exposed to a risk to their health or safety while at work. The only proviso of that being, PPE is not necessary if that risk can be adequately controlled by other means which are equally or more effective. Examples clearly being working from home rather than PPE at work, or potentially the use of splash barriers, or perhaps social distancing, which might be just as effective. But an important aspect of those regulations is that the provision of PPE is necessary, but it also has to be suitable. And subsection 3 of Regulation 4 highlights a number of meanings to this. A few examples are that the PPE has to be appropriate for the risks involved, has to take into account the persons wearing it, and has to be effective to prevent or adequately control the risks involved. On the face of that, then, it appears that there could be a legal case for prosecuting employers who have not provided their employee with PPE or provided them with unsuitable PPE, and that employee has died as a consequence. Importantly, this extends to all employees, not just NHS staff and care workers, but also shop attendants or other workers not in lockdown and exposed to COVID-19. However, to be found guilty of the offence, the breach of that duty has to be gross. And that's defined in the 2007 Act at section 4B, and it states that gross means if it falls below what can reasonably be expected of the organisation in the circumstances. Looking at that then, clearly here the circumstances are unusual, with significant pressures on employers. But more than that, when looking at what is expected, one has to look at the current guidance. And this is specifically catered for in section 8.3b of the 2007 Act, where it states that the jury may look at health and safety guidance to determine guilt. The government has published a number of documents on the use of PPE. In that guidance, they've split employers into two categories: those working in health and social care sectors and those who aren't. There are exceptions to this, with specific guidance for employees working in the police force or cleaning in non-healthcare settings, but largely they fall into those two broad categories. For health and social care sectors, the guidance is in relation to what is appropriate PPE in the circumstances. And this relates to sessional use of PPE in certain circumstances, for example, during a singular ward round when you see a number of different patients. But in other circumstances, such as aerosol generating procedures, where more risks are involved, more precautions must be taken. For all other workers and sectors, the guidance published on the 10th of April states that based on current evidence, there's very little scientific evidence of widespread benefit from PPE. Instead, practicing good hand hygiene and social distancing are key to minimizing the risk of infection. It then goes on to state that the most effective ways for employers to protect their employee is through social distancing and splash barriers, use for signs in the workplace, and regular breaks. The result is that even if that guidance is wrong, it is likely that an organization is only expected to provide a standard as high as stipulated in the guidance. The guidance isn't law, and it does not cater for every situation. Therefore, employers should be wary of providing protection as appropriate for their employee, which takes into account shifting risks and the need to adapt. What is clear, though, is that if that guidance isn't followed and someone dies, it may be then that the employer becomes criminally liable. There are two caveats to that. Firstly, there are likely to be difficulties with proving causation. The question is, did the breach cause the death? Normal criminal causation applies, namely that it need not be the sole cause, nor even the main cause, as long as it was an operating cause that had more than a minimal contribution to the death. And this is complicated enough when you ask, what was the scientific cause of death? In certain circumstances, the deceased may have had underlying medical conditions, which could have been the ultimate reason for why they died. In those circumstances, asking whether COVID-19 had more than a minimal contribution to death is a sensible and effective test. However, it may be more difficult to ask what caused the deceased to actually contract COVID-19 in the first place. In certain circumstances, it may not be possible to prove that the omission of PPE, provision of unsuitable PPE, was how the deceased caught the disease. This is because, given the prevalence of COVID-19, the employee could have caught it at home, on their way to and from work, or perhaps doing their daily exercise. In civil law, this issue has been solved somewhat when it comes to the special rules that apply to industrial diseases, such as mesothelioma, following exposure to asbestos dust. And there, the test is whether or not the breach of the duty of care led to a material increase in the risk of catching the disease. But no such special rules are applicable to corporate manslaughter. Therefore, it may be very difficult to prove that someone caught the disease at the time that the employer was breaching their duties. The second caveat is that guidance on how to use PPE is useless if there is no access to PPE. And one of the major issues we currently face is that there is a severe shortage of appropriate equipment. There's also been guidance provided about this as well. And that essentially states that during these exceptional times, the Health and Safety Executive approves the sessional and reuse of PPE, contrary to health and safety guidance, as long as it is safe to do so. Dame Donna Kinnair, the Chief Executive and General Secretary of the Royal College of Nurses, has called this guidance unacceptable. She says it's unacceptable that any healthcare setting in the UK does not provide PPE as required by health and safety guidance. And this should also be considered in light of the guidance provided by the Chief Coroner, His Honour Judge Lucraft, on the 28th of April 2020. And he states that coroner's inquests into deaths should not look at whether adequate general policies and arrangements were in place for provision of PPE to healthcare workers. And this has been controversial, but it merely restates the legal position that the coroner's court is not the place to investigate public policy. What this means then is that, in my opinion, looking at the information that is available at this time, any prosecution for corporate manslaughter in these circumstances are fraught with difficulties, making a successful prosecution very unlikely. Governmental guidance seems to be making allowances in the employer's favour, both the provision of PPE and the consequences of shortages. But guidance is constantly shifting, and employers must keep abreast of the information provided for them as soon as it becomes available, as that is the metric that they'll be assessed upon. The biggest risk of prosecution arises from the employer's non-compliance with the governmental guidance at the time of the breach. However, it seems that even when that happens, a successful prosecution may still be unlikely without an inherent shift in the law of causation in relation to corporate manslaughter. And that shift must be towards something more akin to the civil rules on industrial diseases. But in any case, it is likely that questions will be asked about the way employers have dealt with protecting their employees during this crisis. And the severity of the current situation cannot be a blanket defense to all negligence. Deaths must be analysed on a case-by-case basis, with any prosecuting authority applying a common sense approach to take into account the exceptional times and extraordinary pressures on employers. There have been concerns raised in the past, most notably with a review by Leslie Hamilton in 2019 that pointed towards issues in relation to the quality of expert evidence and the quality of the processes leading up to criminal investigations for prosecution for manslaughter. However, hopefully these issues have been ironed out, and any litigation will be based on proper scientific evidence with a realistic view of the current circumstances. Thank you for listening.